everyone. My name is Kari, and thank you so much for joining us today on traveling to Canada with a criminal record. I am going to just do a check just to see how we are with our sound and if everybody can hear us. So let me just make sure that we do a check here. Let's do here. All right, so if you can just put in, let's just go to the chat. All right, just wanting to see if everybody can hear us. If you can hear us, if you can send an emoji, send a reaction. You can just raise your hand. Let's see. All right. Just give me 1 second. Okay, so I have raise up hands. Anybody else? Okay, so everybody can hear. You can just raise your hand. Okay, fantastic. All right, so I just want to make sure that we can all hear. Okay. All right, so just wanting to, and if you can just put in the chat, we can just type in the chat so we could see it. So, all right, so we're going to get started. All right, so we're going to get started with our presenter. And I'll start with myself. So my name is Kuri, and I am a regulated Canadian immigration consultant with offices in Jamaica and Canada. I've been working in the business for about 9 years, and we wanted to put on this webinar today to answer your questions that we get often, which is, can I travel to Canada with a criminal record? So today, I want to introduce you to our guest speaker, Annie Baudouin. She has over 20 years of high-level expertise in Canadian immigration. She is a regulated Canadian immigration consultant, and she is the owner of her own consulting firm based in Los Angeles, Baudouin Immigration Consulting. Prior to this, she was a Canadian immigration officer and worked at the Canadian Consulate General in Los Angeles for 15 years. And she has worked on the entire spectrum of visa categories, including criminal inadmissibility originating from the United States and other foreign countries. She has accumulated years of experience in complex permanent residence and temporary residence applications, immigration interviews, illegal presence, investigative techniques, and invaluable concrete perspective of the actual government decision maker. We're pleased to have Annie. Thank you, Annie, so much for being here.
My pleasure.
Fantastic. So, what we're going to do today, just wanting everybody, just let us know, can you see our presentation? If you can just put up your hands. Okay, fantastic. So you can see the presentation. Fantastic. All right, so this presentation is for general information only. It does not constitute immigration advice, legal immigration advice. So it does not constitute a consultant-client relationship. Your circumstances may vary, so please consult with a qualified RCIC or immigration lawyer for any advice specific to your situation. So I'll give it over to you, Annie.
All right. Thank you so much for having me. Today we're going to try to talk about criminal inadmissibility and simplify it because it is extremely, how would I say, complex, and it can be overwhelming. So we're going to try to simplify it and give you a realistic point of view as to whether or not you have a solution and you can go to Canada, whether it's for work or visitor or permanent residence, if you have criminal record, and what are the realistic solution. So thanks again for having me. And I think also we wanted to say that if you have questions, you can put them in the chat. And
or you can raise your hand as well.
Yeah. And we can interrupt at any time to answer. Of course, like if it's extremely specific questions, I'm probably going to try to make it more general so it's beneficial to everybody. But I'm happy to answer any of your questions as well. And criminal inadmissibility is one of my area of expertise. But I also, I like this specific area of immigration practice. So let's get started. So what is inadmissibility? So in Canada and in another country, but in Canada, it refers to a legal term in which a person is not allowed or eligible to be admitted into a country or allowed to apply for a certain type of visa, or it could hinder all of their potential application in the programs, in the immigration program. So it's a general term. And of course, today, we're going to focus on a presentation on what we call criminal inadmissibility to Canada. It is one of the most prominent one where we see the most cases. The other one might be probably non-compliance for people who overstayed in Canada or such a thing. But today we're going to focus on criminality. So what it means is that if you have a criminal record from in Canada or outside Canada, that could create an issue for you to enter Canada or apply for any category of visas. We're going to focus this consultation, of course, on criminal inadmissibility for convictions outside Canada. But we could also do another one maybe at another time on if you have criminality from Canada. So because I worked at the Canadian consulate in LA, I'm very familiar with convictions in the US. And one of the reasons why there's so much, how would I say, information about criminal convictions or criminal charge in the US is because Canada and the US have an unprecedented InfoShare memorandum. So that means that Canada and the US share more information between the two countries, especially on foreign nationals, meaning not US citizens, than any other country in the world. And one of these memorandum of understanding of InfoShare is they share information about criminal records, biometrics, and other level of information. It's also because, let's face it, the US is a very popular destination. So a lot of people visit the US. A lot of things can happen in the US. And that's why there's a high level of conviction and a criminal inadmissibility that originates in the US, but that makes people inadmissible or unable to go to Canada. The other thing that you should know is that as we advance in time and technology and all that, it is very likely that you will get detected if you have any kind of hit in the US. So all of this to say that you may have in the past been able to, we call it fly under the radar, and they haven't caught that you have a hit in the US, but every time you're going to try to re-enter, you're less and less likely that that's going to continue to be undetected. So it is always best to come forward and advise IRCC Immigration Canada that you have criminal inadmissibility or potential criminal inadmissibility. So when you have a conviction from abroad, and we're going to talk, let's say, from Jamaica, you have to basically look at this conviction in the country, in Jamaica, and see if it is equivalent to a criminal conviction in Canada. Sometimes it's not that straightforward. Like, you know, a DUI, driving under the influence, of course, there's one, but there's a lot of countries where offenses are not considered offenses in Canada, and vice versa, right? We can use maybe polygamy, right? Polygamy is a crime in Canada, and in other countries it is very much accepted, right? So the good news is that if there is no equivalency to the Canadian Criminal Code, then even though you have 3 convictions, if those are not equating to crimes in Canada, you are not inadmissible for criminality. So that's the good news. So that's why it's really important to find what is the closest equivalency in Canada. And that's usually where it gets very technical, very complex, very nuanced. And that's where usually people have issues. And then after that, Canada kind of has a 2-tier criminality, which is one that's called serious criminality and one that's called non-serious criminality. And that's all based not on the level of seriousness in your country, but what does it equate to the Canadian Criminal Code? So if you have a conviction, let's say in the US, and it equates to a criminal offense in Canada, you are inadmissible to Canada, most likely for criminality. We'll see that there's potential of solution, but that's kind of the starting point where you should start if that has occurred and there is criminality. So again, I just talked about that already. If you look at the conviction, let's say again, maybe polygamy, and there is nothing in Canada, then you can prepare the documents to show and or include that to your with your application, whether it's a visitor's visa or permanent residence, to show that you are not inadmissible for criminality. So case 1, not going to make you inadmissible. And we've used concrete example that we created so you have an idea of what it can look like. So case 1 is Marcus from Jamaica. He's 29. He was arrested in 2019 in Montego Bay, Jamaica for possession of 130 grams of fresh cannabis, including edible products, liquid, and concentrate. He was convicted in 2020 and served 5 months of probation. So obviously he was convicted in his country. The issue here is that a possession for its own use in Canada for less than a certain amount, which is usually 150 grams, does no longer equates to a crime. Therefore, the person will not be inadmissible to Canada because as of October 2019, you can legally possess 150 grams of fresh cannabis in Canada. So even though this person has a conviction in Jamaica, it does not make him inadmissible to Canada. It does not prevent him from applying or entering Canada. And he should just include the documents that show what this is, what is the equivalency in Canada, AKA there is none, and therefore the person is not inadmissible. So of course there's an added burden because with your application, let's say a visitor's visa, you should add some information about this criminal conviction. You should not try to not disclose it. You should not try to hide it. You should disclose it and make add some documents to make a legal point that you're not inadmissible to Canada because there's no equivalent crime in Canada. If we look at the next scenario, which is scenario number 2, so it's someone who will need a criminal rehabilitation application, or often also called criminal rehabilitation approval. So let's look at that. So let's say, well, first, sorry, let me describe it first. So criminal rehabilitation is an application that, if approved, will allow the individual with past criminal convictions outside Canada to overcome their inadmissibility and be able to enter Canada legally. It means that the person has demonstrated to Immigration Canada that they are reformed, that they now lead a stable lifestyle and are highly unlikely to commit new crimes that could put the safety and the security of Canadians at risk. That's what the goal of criminal rehabilitation is about. And then when we prepare those for our clients, that's what we try to convince the officer with a different set of factors that the person is very unlikely to reoffend, and therefore they will not be a potential risk to Canadians and Canadian society.
I just want to pause you for a moment. I just want to see
Yes.
if anybody has any questions. I'll just see. I'm sure if they're able to see the chat, but I just want to see if anybody has any questions. They can raise their hand.
Can
Okay,
someone? Yeah.
Get their someone could get their police record in Jamaica to see the document that will be issued to the government of Canada, or do we get our own copy for ourselves? So my understanding is when you apply for a police record, then you get your own copy, and that's what you're going to upload. So that's going to be what would happen.
Yeah. So there are some countries like Mexico gets sent directly to the consulate, but it's rare. But in most countries, especially if you have and you have potential hits that are going to show up, then it's highly recommended that you get that police record so you see what Canada's going to see. The thing about police records is that they're not always extremely reliable. And I'll give you an example. So the FBI doesn't always show all charges and conviction from all states, U.S. states.
Okay.
So often what I've seen in, dealing with these cases is that the FBI only shows one hit, but there's actually 3 other hits. And that's because the states often do not have a good info share system with the FBI. So what can happen, I've seen this happen in other countries too, is like if you request your police certificate and you see that there's discrepancies, then you should try to get it amended, try to get additional information, and you should not try to say, oh, well, it doesn't show up on my police certificate, so therefore I am not going to declare it. Nope. So it's always much, much, much better to take the safe route, which is whatever's happened, whatever is the truth, that's what I'm going to declare. And if the documents that I request are not in line with that, then I'm going to make sure that I explain why. I've seen other people too, where they say, I've never been charged or convicted of this, and it appears on my police certificate. So I think your question is very good. And I think that, you should always try to look at what's your police certificate to see what you're dealing with and making sure that it's accurate. And that you don't have any surprises.
And just as a note to Angela, in Jamaica, what they'll do is that if there's something on your police certificate, they won't actually issue one until you have to have something sort of attached to that. So so you may have to do a little bit more investigation if you weren't aware of what was on your police certificate.
Yeah. So great question, by the way.
Any other questions before Annie continues? Angela, I see you typing there. So I'll just have Annie continue, and then we'll just ask as we go along.
Okay. So we talk about, for rehab, we talk about a prescribed period. What this means is that you cannot apply for rehab anytime you want. The reason for that is that rehab will erase your criminal inadmissibility to Canada forever, unless, of course, there's a new crime that happens after. So it is an application that you can only apply after a certain enough time has passed. And that's what we call the prescribed period. So in a criminal rehab, no matter how many convictions you have, no matter if they're serious or not, you need to show to the officer that 5 years have passed since the completion of all terms of your sentence. If that cannot be proven or that is not the case, don't apply for rehab because you're going to get rejected. Okay, so you should include a document that shows that all the sentences from all the convictions have been completed over 5 years ago. And what I was saying is that sometimes we would see people that would have 20-year-old conviction, but there's $5 remaining to pay, and they haven't paid it, and they are unaware of it. That will block them from apply for rehab. So that's kind of another extremely important verification to do, is like, am I eligible for rehab? So if you have only conviction, just make sure that you completed all terms of the sentence. That includes sometimes, probation, fines, jail time, whatever the terms of the sentence, they should all be included and should be completed. And 5 years from that date must have passed for the person to be eligible to apply for rehab. So let's say we give you a concrete example of someone who can be eligible for rehab. So we have case 2, which is Tanya. She's from Trinidad and Tobago. She's 30 years old. She was arrested in Texas. She threatened a coworker with a knife, which is an equivalency most likely to 267A of the Canadian Criminal Code. She was convicted in June 2021, and she served 6 months of prison. No other terms of the sentence. She was only asked to serve 6 months in prison. So if we add 6 months to June 1st, 2021, that puts us in December 2021. If we have 5 years to that, that puts us in December 2026. So if Tanya wants to apply for rehab, she cannot do it until December 1st, 2026. Of course, she can prepare the application before that, but she should not submit it to IRCC until that date when she becomes eligible for rehab. If anything else happens between that time, then she may not be eligible for rehab anymore. So the person has to stay, of course, free of charges and conviction before the 5 years, and then after they apply, to continue to be considered rehabilitated and no longer inadmissible to Canada. So just to kind of make it clear, rehab is your number one amazing solution if you're eligible, because it's going to remove your inadmissibility forever if nothing else happens. That means that once you get that rehab approval letter, you can always show that to say, I am no longer inadmissible to Canada. Okay.
Do you have to apply for it each time? Like, so that would you have to?
No, it's permanent
each time. Okay.
Unless there is a new conviction. So what I tell my clients is that, let's say a few years have passed and you have your old rehab letter, just bring your police certificate showing that there's no new convictions, because you have to continue to show that. But usually they'll accept the letter. So that's what the beauty of rehab is, that it's permanent if nothing else goes wrong. So you don't need to worry about criminal inadmissibility.
Right. And then do you include that letter in each application, or does it stay on your file?
100% I would. Anytime you enter Canada, anytime you put an application in, you include a copy of that letter to show that you have done the due process and you are no longer inadmissible to Canada for criminality. Never lose this letter, ever. It is extremely important.
Okay. Yeah. We have a question from Marcia. So Marcia, it sounds like a very specific question, but I think we'll get to it later on, which is, what about a person accused of lying to a police officer, got volunteer departure? It sounds as if you were asked to leave the country after charges dropped against that person.
Okay.
Sounds very specific, but I think we'll get to like dismissals and so forth.
Later on. Yeah. So I can talk about it in general terms. So if there is only one charge and there was never a conviction, or there was a conviction that was pardoned, dismissed, expunged, you could potentially no longer be inadmissible to Canada for criminality. How would I say? The danger in that is to thinking that because it was dismissed, it's always going to lead to, I'm not inadmissible to Canada, because there's different level of dismissal. It depends. So in general term, usually it'll be accepted. I'll give you an example. Let's say the case went to trial and it was dismissed. There was no verdict of convicted, then that usually work. But often what happens is that there is a conviction verdict, and then later on the person can request a dismissal. And there's different levels of dismissal. There's dismissal where the charge is dismissed, but the conviction remains in the records. That won't be accepted by Canada. So that's why be careful to say, oh, it's dismissed, so I'm free and clear. No. In the UK too, there's a Rehab Act where after a certain amount of time it's spent, Canada will also recognize that, but only in country where the justice system is very similar. So if Thailand had a Rehab Act of spent conviction, probably won't recognize that. But UK is one of the country where Canada will recognize it and say, okay, we recognize that you're no longer inadmissible to Canada for something that you have. So I hope this answers your question. But yes, if it was dismissed, depending on the dismissal and the wording of the dismissal, there's a good chance that if that's your only charge or conviction, you're not inadmissible to Canada. And of course, you're going to want to bring your police certificate showing the dismissal, the court paper showing the wording of the dismissal, the legal statute, foreign legal statute in your country showing what the dismissal is equivalent to really show the officer that there is no conviction. It's a full dismissal. If there is a doubt in the officer's mind that there was a conviction and it's still remaining, that's when it can become tricky. Good?
Yep, thank you.
Okay. So, again, this is the other beauty of criminal rehab is that you can apply if you're eligible for rehab and you want to go study in Canada or visit in Canada. You can but you should put these applications together and submit in conjunction to IRCC. That way, they're able to review your criminality, and if your rehab is approved, then there's a really good chance that your visitor's visa or your study permit or work permit is going to get approved because you're no longer inadmissible to Canada. If your criminality is refused, automatically that study permit, that work permit, that's going to get refused, right? For permanent residents, there might be what we call an HNC, humanitarian consideration, that could, create a potential opportunity to still get an approval, even though you're inadmissible and the criminal rehab is refused. But that's something we could talk maybe if we have time. But in most cases, that's what's going to happen. Criminal rehab approved, visa approved, criminal rehab refused, automatic refusal, right? Next, let's see. Okay, so let's talk about scenario 3, deemed rehabilitated. Deemed rehabilitated is also, a great avenue to no longer be inadmissible to Canada forever if there's no new conviction or charges. And here's what happens with deemed. So in order to be deemed, the person has to have only one conviction from outside Canada, and after a certain period of time, they will automatically be considered rehabilitated or deemed rehabilitated without having to receive a letter, without having to submit a form like the rehab, without having to pay a fee. But in reality, if you are claiming that you're deemed rehabilitated, let's say on a visitor's visa application, even though you're not going to have to include a form and pay a fee like the rehab, you will have the burden of proof to provide the documents to convince the officer that you are deemed rehabilitated. And you're going to do that by establishing a couple things. You're going to want to establish that you have only one conviction. There's another technicality for summary conviction, but it's very rare. So I'm going to stick to the most prominent scenario that we see. So you can only have one conviction outside Canada, and it cannot be equivalent to serious criminality in Canada. And I guess the line is drawn in Canada on 10 years, and 10 years is included. So if you look and you have a criminal conviction in your country and then you equate it in Canada and it says in the criminal code, this is punishable by terms of 10 years, 10 years or more, including 10 years, boom, you're serious criminality. You will never be able to be deemed.
Can you
If you
repeat
look
that?
at,
So
yes,
if it's 10 years, if it's up to 10 years, including 10
yes.
years.
So anytime it says 10 years or more, if the word 10 years is included, it is considered serious
So if
criminality.
they say up to 10 years, yeah.
Up to 10 years, that includes, you won't see that in the criminal code. So
Yep.
usually when you see a 10 years in the criminal code, you're in that route. You're in that route. Because the criminal code, the wording is very confusing, but it'll say 10 years or more. So basically, if it's 10 years, 9 years and 365 days is 10 years, you're serious crime. So you won't be able to ever be eligible to be deemed rehabilitated. Okay. But let's say your conviction is equivalent to, of course, if it's 14 years or 20 years, of course. So anything 10 years and above is serious crime. If the conviction is less than 10 years, not including 10 years, so let's say it's punishable by terms of 2 years, then that is what we call a non-serious equivalency to the criminal code. And if you have only one, and 10 years have passed since the completion of all terms of the sentences, you are no longer inadmissible to Canada. Okay, I'm going to repeat that. You have one conviction. The equivalency to the criminal code is not serious, less than 10 years. And 10 years have passed since the completion of all terms of the sentence from that one conviction. You are considered deemed rehabilitated. It happens automatically when the 10-year goes by, poof, and you can go to Canada. But of course, you're going to have to show that to the immigration officer if you apply for a visa, if you're going to the port of entry in Canada, and you will show that with a police certificate showing there's only one conviction, court record showing that it's the legal statute is equivalent to this in Canada, and therefore it's not a serious crime, and completion of sentence of all terms of sentence occurred all 10 years ago. You don't need to pay a fee, anything like that. I do want to say that port of entry officers are known to make mistakes on deemed. I've seen it so many times. So, but most often, like if you're deemed at the border, it'll stand. But I've had so many cases I've saw that I would see like, wait, like, what are you talking about? Like this person is not deemed because they don't have how would I say, the local knowledge to do these type of things. So sometimes there can be a time where the officer will come back on that, but usually they'll be facilitating the rehab and things like that. But most time, once you have a deemed rehabilitated status established, you can request the notes on a file or things like that so that you can keep that as evidence that you've been deemed and there's nothing new that's appearing on your record. Do we have more questions?
No more questions at the moment, but remember to type them in and we can answer them as we go along.
So for Dean, we're going to talk about case 3 to give you a concrete example. So case 3 is Tyrone from Guyana, 40 years old. He was arrested in London in the UK for theft of $4,000 Canadian equivalent. So that's punishable under Section 334B of the Canadian Criminal Code because it's less than $5,000. At $5,000, it becomes serious criminality because it's punishable by more than 10 years. But luckily, Tyrone, it was only $4,000. So that's his only crime. He's never committed anything else, never been charged anything else. So he was convicted in October 2013 of theft $4,000. That's equivalent to non-serious crime in Canada. He served 1 year in prison and 1 year of probation. So if we add 2 years, 1 year probation, 1 year prison, to the October 13, that puts us at October 2015. And then remember, to be deemed, that is 10 years. So October 2025. So what this means is that in October 2020, if Tyrone needed to go to Canada, he was eligible to apply for rehab and could have applied for rehab and may have been approved. Because remember, rehab is 5 years to be eligible to apply. Doesn't mean you're going to get approved, but you're eligible to apply. But if he doesn't need to go and he just wants to wait to automatically become dean, then he could have waited for October 2025, and then he enters the 10 years since the completion of the sentence, and then he's deemed. He doesn't need to apply for rehab. He doesn't need to pay the fee, anything like that. In a sense, rehab is great because you will get a letter. Whereas to deem, usually it'll appear in the notes of the officer and things like that. So some people, they just say to me, just apply for rehab. I want a full assessment RCC. I want that letter, even if I'm deemed. And then if you do that, often the officer, because I used to be the officer in that, will say, you're deemed rehab. So they'll give you that letter. And for non-serious crime, the rehab, it takes a long time, but it's very cheap. It's 229, I think now, or 200 and something. So sometimes some people just say, you know what, just apply for rehab. I want that letter to always have in my pocket.
So is it common sometimes for an officer not to send you a letter if you're deemed rehab?
Well, they will never send you a letter, actually. Okay. It'll appear only in the notes. No, I shouldn't say never because there's nothing never in, but it's very, very rare. So let's say you're applying for PR, permanent residence, and you are putting forward a case that you are deemed. Well, the only thing you'll receive is your approval. But if you see in the notes, you request the notes from the agent, the ATIP notes, you'll see that there's been a determination of deemed rehabilitated. But the letter won't say it. But if you're approved, then you know, okay, the officer accepted my legal argument that I was deemed. But it's very, very rare that it'll appear. So what you'll have is an approval of your study permit. Boom, you know that they accepted the deem. That's why some people, they just want to have that document in their hand because it's very stressful for some people when they get caught at the border, especially if they've been crossing in and out with never issue, and then boom, all of a sudden their criminal pass is a major issue. So they just want to have that extra peace of mind and safety of that letter. So that's why they do it. And that's possible. And if you look on the rehab form, you'll see it says on top for information only, was right. Back in the day used for deemed often, but IRCC in the consulate office.
Let's see. It's just checking if Annie's still there. I'm just checking if everybody can hear me. She might have been. Can you type in? Oh, there we go.
I don't know what happened.
You're good. Okay, good. You're back. Great.
Okay. So wait, where were we? Let me see. This we did. Okay, so we did this. Did I answer your questions?
Yes. Well, yeah.
Great.
Yes.
Now we're going to talk about something else that could also be beneficial. So if you were convicted as a juvenile, which is 18 and under, you most likely are not inadmissible to Canada for immigration purposes. So if you're able to show, and most often too, even if you were trial as an adult, Canada will recognize that you committed the crime before you were 18, and what happens after that is kind of not relevant. So if you do have some criminal conviction before you were 18, most likely this does not make you inadmissible to Canada. You could provide the documents to show the officer that if you apply for something, but it shouldn't be a concern for criminal inadmissibility in Canada.
And that's 18 and under.
Yes, 18 and under. Yeah. So if the person was arrested on her 18th birthday or 18th and one day, nope, out of luck, not gonna fly. Yep. So there are two ways to become rehabilitated. So that's this slide is a summary of what I just discussed, so you're able to put it in perspective and see where you may fall. So you could become rehabilitated. Number one, if you're deemed rehabilitated, again, there's specific criteria that you need to meet. One conviction, non-serious, 10 years, and the person has the 10 years have passed. Or number two, you weren't, most of the time you weren't eligible to be deemed, so you had to apply for approval rehab, or you apply for approval rehab because the 10-year hasn't passed. But either way, those things are the main way to remove the criminal inadmissibility, hopefully forever, because after that you're never going to have issues with the law. That's what usually it looks like. So for the rehabilitation, the client must file an application with IRCC and pay the processing fee. The processing fee, if you have even one serious criminality, so let's say you have 4 non-serious crimes and then 1 serious crime, it doesn't matter. It's going to be the high processing fee, which is over, I think it's 1,000 something now, right? It's over $1,000. If you have 65 non-serious criminality, it'll still be 220 something dollars, which doesn't make sense to me, but that's how the government. So as soon as you have 1 serious crime, you are asked to pay for the serious criminality. Often people have a hard time determining that. So you can always say to the officer, I'm unclear if this falls within serious criminality. And what I did as an officer is I would say, yeah, it is serious crime, so send me the extra money. So if you want to be safe and you don't want to have to wait for the refund of IRCC because it takes forever if you think you're non-serious, you could pay the non-serious and see if the officer thinks that the additional fee is required later on. Let's see. How are we doing on speed? We're doing good?
I think we're doing
Not
good.
going too fast? Okay.
I don't think so. Anybody have any questions that they just want to type in?
And keep in mind, like everything you say here is confidential, and so this is a safe space. So whatever you want to ask me, now's the time. Because I know there's so many complexity and intricate situations. So sometimes this is what this is good for. So now let's talk about dismissal, expungement, and pardon. Those are different terms that often could potentially create the possibility that you're not inadmissible to Canada. So you don't need to be deemed. You don't need to apply
I'm just
for
going to ask you
rehab.
to do something. Could you
Yeah.
stop and start your video? It just seems as if you're stuck. We can hear you, but it just seems as if you're stuck. Just for the... Are you able to? We can hear you. Hello?
Can you hear me?
We can hear you. We can hear
Okay.
you.
So should I go on?
Yes. Definitely go on.
Okay. So dismissal, expungement, and pardon. So in addition, some full dismissal will completely remove the convicted verdict and could potentially allow someone to return to Canada without having to apply for rehab. And often too, what I would see or what I see is that a client has, let's say, 5 convictions, 2 are dismissed, but 3 remains. So that means you need to apply for rehab. As long as there's 1 that remains. So this only applies if all your convictions have been dismissed, fully expunged, or pardoned. Otherwise, you still need to apply for rehab. I just want to make that clear. So again, I kind of already touched on that, but not all dismissal are created equal in the eyes of Immigration Canada, of IRCC. So the tactical and important things to show is that the dismissal, the expungement, and the pardon has fully removed the guilty verdict. In a lot of countries, a lot of US states, there is a dismissal, but the guilty verdict remains. So it cannot be used for job application like that. If the wording of the dismissal, and you have to go read exactly under what statute you were dismissed under, still leaves a doubt that the conviction remain, there's a high probability that they will not accept that as a full dismissal, and you should apply for rehab. In cases of doubts, apply for rehab. Because when you apply for rehab and you pay the fee, the officer will have to assess it. So you could receive a letter that says, I'm satisfied that this is dismissed, therefore you're not inadmissible to Canada anymore. Instead of sending you a letter that's going to say, your rehab has been approved. So that's the beauty of rehab, is that you're going to have a final determination. You're going to know for sure where you stand in IRCC, and you're going to have that letter in your pocket that really shows where you're at in terms of criminal inadmissibility for Canada. So I would say, when in doubt, apply for rehab. And if you have a Canadian conviction, then you can ask for, it used to be called a pardon, but it's now called a record suspension. And that's done through an entire process in Canada. But today we're really focusing in foreign convictions from outside Canada.
Again, if there's any questions, you can type them in the chat.
Okay, what to do if I'm not eligible for rehab yet? I'm sure a lot of you have this question, right? So you have a big event in Canada, your sister's getting married, but the completion of the sentence, there's not 5 years that have passed, so you're not eligible for rehab. So is there a solution? Yes, there is. The solution is called a temporary resident permit, not to confuse with temporary resident visa, which is a visitor's visa. A temporary resident permit is called a TRP, and it is used, by the way, not only for criminality, it's used for pretty much anything and everything that is causing a problem to enter in Canada or in non-compliance with the act. So the TRP is a great band-aid or solution for anything. But in this presentation, we're going to look at the TRP to be able to go to Canada if you have one or several criminal convictions. So you have also, what I should say too, is that criminal rehab take forever to be assessed. So sometimes people, even though they're eligible for rehab, if they have a last minute trip, they will attempt to get a TRP and, let's say, a visitor's visa to go to their sister's wedding, even though they're eligible for rehab, and then they'll say, I'll apply for rehab later. So TRP, being eligible for rehab, is what I want to say, does not preclude you from applying for TRP if you have an urgent trip, you have compelling reasons to go to Canada. And just like we did for the rehab, you're going to apply together with whatever application you're submitting. If you're a US citizen or US permanent resident, you want to go for a visit, you don't need a visitor's visa, so you're going to apply for a TRP at a Canadian consulate in LA, right? You're not going to provide it with any other application because you don't need it. But if you do need a visa to enter Canada, you're going to submit those together to IRCC, the TRP, and whatever the work permit, the study permit, or the permanent residence application. And what that does, usually if the TRP is approved, just like the rehab, you'll probably get the application approved, and it's usually for a short term. The TRP is a quick fix for a short term. It does not remove the criminal inadmissibility forever like the rehab does. So it's really to allow you entry for a short period of time in Canada for something very important. We're going to talk about that. So you're not eligible for rehab, or you have an upcoming trip and you cannot wait, 9 months, 12 months for your rehab application to be reviewed. So you're going to apply for a TRP, and if it's approved, it's going to be a remedy to any kind of issue, in this case, criminal inadmissibility, that's preventing you from entering Canada or getting your visa approved. And so basically you submit your TRV with your visa application. If the TRP is approved, you will most likely get your visa approved as well. So that kind of answers a lot of questions that people are saying, can I go to Canada if I have a criminal conviction? So the answer is yes. And there's several ways, but it depends if you're going to be able to secure the TRP or the rehab, or if you have a criminal conviction that is rendering you inadmissible to Canada. So for the TRP, there needs to be a compelling reason to Canada. So if you're going just to visit the CN Tower in Toronto, it is very unlikely that you'll get approved. But if you're going because your mother is a very sick, and they're going to be most likely dying in the next few weeks, and you want to pay your last respect or things like that, those are compelling reasons. Most of the time too, and that's what we did a lot in LA, is if you have we saw a lot of actors or rock stars or sports athletes that will bring tremendous amount of visibility and lots of money for the Canadian economy, right? Like Britney Spears, let's say, right? So we would issue a visa so she could do her concerts and bring all this money for the economy. So the TRP, there needs to be a compelling reason, and that's at the discretion of the officer, but it needs to be very compelling. Not just, I want to go visit my friend that I haven't seen in 20 years because I feel like going there. And it needs to be something concrete. There is a lot of discretionary power into what is compelling reason. So you can always make a case for it and see if the program manager and the officer will be recommending an approval. But most of the time, you really need to do a very good job as corroborating with documents what is the compelling reason. And the reason usually cannot be it can be beneficial to you, but it must be, you must show that it is beneficial to a Canadian or to Canadian economy or to Canadian culture or anything like that. So don't relate the benefit to you, the foreign national, relate it to the Canadian economy or things like that. That's the way to increase your chances at approval for TRP. So we've given you some example. So visit a family who's sick, accompany a spouse to see their family, concert that will generate millions of dollars, hockey player playing in an NHL game, training employees at a specific company, speaker at a conference. So if you're attending a conference, you're just attending it, versus you're the main speaker who's going to be talking about the new research and development that's going to be potential to find a cure to cancer. You see the difference, right? So the person just attending the conference may not get the TRP, but that high-level scientist who is involved in the research and development of a new cure for cancer is going to be speaking, will probably get it. So it's all about, but you can document it and still take a chance, because sometimes, the discretion of the officer is can work in your favor. Compelling reason, again, must show a benefit, not focused mainly on you, but more towards Canadians and Canadian safety. And really, the exercise that the officer does is they're going to assess whether the benefit is outweighing the risk of letting someone who's inadmissible, in this case a criminal, to Canada. So the more compelling, the more chances you are having a good chance. And if you have a very long criminal background with very violent crimes and things like that, you better have a really compelling reason. But if you just have an old conviction and you have a pretty good, so every case is going to be different, basically. Case by case is what we call. All right. This is one question that we get all the time. I've been going to Canada every year for 20 years, never have an issue. And then 3 years ago, I was asked the question, and they did a background check or a name check or whatever it is. But now they know I have a conviction. Canada knows, Port of Entry knows. It was a big ordeal. It was stressful. They allowed me in or they didn't allow me in, whatever. So the question is, what does that mean for future entries? It means that almost at 100%, any future entry that is in the system, and you will not be able to continue to enter Canada without addressing this criminal inadmissibility. So once you know for sure, then you need to take the step to apply for the TRP, the rehab, show that you're deemed, whatever it is. But don't ignore it and try again. The immigration officer is not going to like that, because once you get caught, they will tell you, do not attempt to do this again. You need rehab. You need this. You need that. So please don't insult the intelligence of the immigration officer, the port of entry officer. And then as soon as this happens, if you're planning another trip to Canada, take the necessary step in advance to get your rehab approved for your next trip or whatever.
So we just have a question from Angela.
Yep.
Just asking a question. It might be outside of what we're speaking about. So she's asking, where can we get more info about what is discretionary versus strictly defined criteria for admission? Example, employment history, education, etc., not just criminality. And I think this is going to depend on the type of application, because if it's temporary residence, that's different from permanent residency, right? In terms of what is,
Yeah. So the thing that you've touched on is that anything that is discretionary or within the discretion powers of the decision maker is purposefully on intent, not defined in the law, not defined in the reg, left very, very vague, even in what we call guidance manual. Because if there is discretion, they want the officer to be able to apply it in a fair and open-minded manner. So IRCC will try not to give too much guidance on it. So you won't be able to find a defined specific criteria like, oh, we need to meet that number, or that is always approved. You will never find that when there's a large, wide discretionary power. And when we're talking about criminal inadmissibility and TRPs, doesn't get much wider than that.
Right. So they leave it up to the officer.
That's the intent. So an officer could look at it and be like, oh, that's a long criminal record, but I'll let them go see their sister for 5 days. And then the next guy comes in and says he only has one conviction and he has a super compelling reason, and the other officer will say, no, not satisfied. And that's all, I guess, desired in the immigration law and for the integrity of the program. So if we had these criteria and they existed, that would make our job easier, won't you think? But it doesn't exist. But what it also does is that it provides an opportunity for you to put forward a very well supported case, make a really good argument. So these type of applications are complex, and the more supported there are, the more legal argument are well worded and meeting the definition that the officer is looking at. And I told you that, right? During a little bit, I said, the officer will want to weigh in the risk of the benefits. So of course I prepare a lot of these applications because it's my area of expertise. So I know exactly the wording that the officer is looking for. And that's what I do. And that can help also, but it doesn't guarantee. But I would say these are the type of the application that you should spend a lot of time ensuring that they are well documented, well presented. Otherwise, it is not an easy type of inadmissibility to overcome. It is not. It's just very serious. Criminality is very serious. And the officer doesn't want to let someone in that's going to cause a lot of issues, right? So that's why they're very reluctant to approve it. They don't want that to happen. And there's been horror stories where someone was issued a TRP and then they got into Canada and went on a rampage, right? I had my story too, where we issued a TRP for a star, no name is going to be mentioned. And then I'm in LA and I turn on the TV, and here it is. That person is in a hot pursuit with the LAPD and trying to flee the country for me. So that person, I just issued a TRP to go to Canada to do an event. And then I'm like, that person is a extreme danger, just went from So frantically calling the border, like cancel the arrest,
cancel,
right?
cancel, cancel.
Right. So that you see what it means, right? So, but that's what it's about. So it's about things changing and discretion and all those things. That's what it can come down to.
Okay, so we have another question from Marcia, which is just a question. A teacher with a bachelor's degree decided to move to Canada to study and work with her family, but the husband, who's a senior, has a bad criminal record in USA more than 30 years ago.
Okay. What do you mean by senior? Like he's older?
I think that's probably what she's saying. If it's 30 years ago, he's
Okay.
maybe 30 years on.
We're going to talk about that. So, what we call the passage of time is one of the criteria that has a lot of weight, positive weight, in the probability of getting your rehab approved. So that is great. That is great. It's only one of the factors that the discretionary power of the officer will take into consideration, but it is a heavy one. Okay. So that is great. If a lot of the passage of time, a lot of years pass since the completion of the sentence, because what it shows to the officer is that if in the last 30 years the person has not reoffended, the likelihood, statistically speaking, they're probably never going to do it, right? So that's why the passage of time is one of the main criteria that the officer looks at. So the more time you have since your last conviction, the better. And that's why I remember they say, well, if 5 years haven't passed, we don't even have enough time to tell if you're going to reoffend. So we're not even looking at your rehab. So that's what the same kind of mentality comes in. So the more time you can put between the offense and the time you're going to apply for whatever visa, rehab, the better.
Sounds good.
So I've already touched on this, and I think that in this day and age, because of all the new additional features of security and biometrics and all that, it is really the worst strategy that you can take upon yourself to navigate immigration to Canada in any sense of form, is to not be straightforward and honest about anything. And when we're talking about criminality, I would say that's 5 times more important because it's so serious. So you could provide a rehab application, but you forgot to declare a charge that doesn't make you inadmissible to Canada. That's going to affect the credibility of your application. So you want to be extremely thorough and declare everything, even if it doesn't make you inadmissible, even if it doesn't appear on the police certificate. Declare everything. Because misrepresentation, which is basically lying or not being honest with IRCC, is one of the most serious crimes under the Immigration Act. And not only, so you could be refused for rehab and you could be found inadmissible for having lying or misrepresented, and add to your additional burden of trouble 5 years of ban from Canada because you just lied on your rehab application. So you're trying to get rid of your inadmissibility for criminality, but you're not being honest on your rehab because you think it's going to hurt, or whatever reason your representative doesn't know what they're doing and they're telling you to do that. It's going to hurt in the end. So also, rehab, the concept of misrepresented includes not providing information. So omitting to provide it. So it's not just providing false information or trying to mislead or incomplete. If you knew this and you didn't tell the officer, that's sufficient to trigger that misrep and 5-year ban. So it doesn't get more serious than this under the Immigration Act. So please, the golden rule is declare, declare, declare. And if anyone, whether it's your lawyer, your cousin, your sister, is giving you advice about Canadian immigration and they start telling you, no, you don't need to declare that, they're not going to find out, run. Do the opposite. I was an officer for many years. I've done this for, that is the worst advice you can possibly receive. Always be truthful. Declare every summary, every conviction, every juvenile conviction, declare it all. It also shows to the officer that you are straightforward and honest and that you are trying to do the right thing. You're not hiding anything from the officer. You're not trying to embellish anything. You're declaring it. this is who I am.
And remember
Officers love
that,
to-
right? And sometimes it's also a cultural thing as well. Like in some cultures, when it comes to the government, the strategy is to not give as much information as possible in some cultures, but in the Canadian culture, it is important that you do share
Yeah,
everything.
100%. That's a great advice. In a lot of country, you navigate your government, corrupted government, whatever it is, in a very different way, right?
Right.
In Canada, it doesn't work that way.
Right.
And the what we call the responsibility is always on the applicant to be truthful. And to be honest with you, you're gonna gain because often if you are truthful with the officer, they're super lenient. I was that way. If you came forward and you were honest and you stopped lying to me as the officer, usually I would find a way to make it happen. But if you continue to lie, omit information, keep information that you don't want to bring to light, it is the worst possible way to start an application. A list of documents to provide with rehab. Again, every case is different, depends on the situation, depends on the terms of the sentence, depends on your background, but this is kind of a starting point or a general list that's non-exhaustive. So let's see. Of course, your police certificates, they must be recent. Your letter of recommendation from professionals or well-known citizens and people that have been that know about the conviction, know about the process that you've been through to reform yourself, right? So let's say you were convicted of 2 DUI. Well, you're now part of the AA, the Alcoholic Anonymous, and your sponsor is going to write this great letter to say that you've been sober for 15 years. That's great. Proof of completion of therapy, counseling sessions, victim panel, proof of paid compensation to the victim, documents showing completion of a rehab or a detox program for substance abuse, documents showing participation in life skills, social survival skills, anything to show that the person that you were then and that committed that and the event and circumstance surrounding these events are completely gone. And that statistically shows to the officer that it's very unlikely that you'll reoffend because the climate that was there when you offended is no longer there. So that's why you want to show in any way possible how different your life and you are. So these ingredients that were brewing that led you to commit this crime are no longer there. So therefore, you're probably not going to commit another crime. So you went from spending time in jail to getting your master's, your PhD. Now you're going to accomplish whatever. That is sufficient often to convince the officer, like, this is not the 20-year-old guy who did this. He's not going to do it again. He has a family. He has a career. He's changed his life completely. Reference letters from individuals who know about your criminal past, proof of involvement in community, participation in volunteer activities. Like I would see a lot of application from people who had a lot of substance drug charges, and then they become counselor for people involved. Like that really shows that they have completely changed side of the fence. And now they're actually giving back to try to prevent people from going down their path. These people very rarely reoffend. Information about change in family situation, responsibilities, employment letters, anything else that you can think of that would show to the officer that you are rehabilitated and what happened then is not going to happen now. Let's see. Next slide.
Or you think the last one might have been submission letter as well?
Wait, hold on. I think I lost you for a minute.
Oh, can you hear me?
Yep. Yes.
Okay.
Okay,
I think
so
it might be submission letter. Be the
yep.
the one before that.
Example. Okay, that kind of answer one of the
Yes.
questions, but in a very large general way, right? So example factors taking into consideration for approval of rehab: the seriousness of the offense, whether there's violence, whether there's sexual crime, the chances of committing further offense, any behavioral medical factors involved at the time of the offense, major life changes, evidence of reform and rehab. It's all tied to the documents I've given you. Whether the influence of drug, alcohol, medical condition was a factor then. Is there a pattern of criminal behavior? There you go. Passage of time. Time elapsed since the offense. Controversy of risks or cause of presence in Canada. Have you ever been to Canada on a TRP and nothing ever happened? Nothing went wrong, so therefore they're probably going to do it. Expressing regret and remorse and taking responsibility for what you've done is a great way to convince the officer that you are rehabilitated.
Mhm.
Anyone that says it wasn't me, I didn't commit it, it's not good. So you want to take remorse. You want to write a letter explaining why you did this, why it changed your life, why you would never do it again. Violent crimes, nonviolent crimes are sometimes difficult to to justify, but again, it's it's case by case, right? So someone could have been driving under the influence, and I had someone, they killed their best friend because they were very young and driving drunk.
Yeah.
And the amount of evidence that person has had provided to show the steps that they have taken and the guilt and what everything they have taken, and how the life, and and the letters from the family of the friend that died, like, so there's nothing that's never unrecoverable, right? Because that person killed someone. Like, you could tell, like, so, right, so it could be, so someone who's hit someone because they were driving, they weren't under the influence, but they were driving recklessly because they were mad that day and they hit someone and broke their leg, might get refused, and the person who actually killed their best friend because she was driving drunk might get approved, because
Right.
the case is supported differently, the circumstances are different, and the person's able to show this event has changed my life, and you can see every single step of my life I have tried to make up for this mistake. Someone who does that will not reoffend, or it's very unlikely, right? So that's how the officer will look at it, and that's where the discretion comes in, and a lot of things happen in the evaluation of the officer, of course. The submission letter. So the submission letter is very important in my case, and you could, like, that's what we're going to say, we offer a lot of services. Sometimes you could just hire us for consultation to help you make the application better if you don't have a limited budget, or you could just hire us to help you draft the submission letter, or to ensure that you've covered the major points in the submission letter, because the submission letter is very important, because TRP rehab application, the application in itself doesn't capture a lot of information. And these discretionary remedies are need to be well supported, well explained. You need to paint a picture to the officer in order to have anything approved in these type of category. Just like I've told you, the case of the best friend killing her, the young drunk driver killing your best friend. Like, if they had given me that with no context, no nothing, refused, right? But it came in, it was well explained. They told me the whole story about what happened and what followed, and that made the difference. And it's like, okay, then I'm going to approve you. And what should you include? Well, in the submission letter, if let's say you're applying for rehab, you should basically try to address, or at least provide details, a few paragraphs, for any of these things, any of these factors that apply. The seriousness. What my conviction wasn't that serious, it was this. The chances of committing, 15 years have passed by, so the passage of time shows that. What behavioral were involved at the time? At the time, I was under the influence of this drug. I have been sober ever since. You have 5 letters on file to show my sobriety, right? So all this needs to be kind of really explained in the submission letter, so that the officer can understand, and that will, of course, increase your chances, significantly increases your chance at an approval. When a letter expressed remorse, so often the handwritten letter by the applicant that explains the remorse and the regrets, to me, it was always a very important part that would often swing my decision towards an approval if it seems sincere and comprehensive and things like that. And it's okay to be vulnerable and so not a month goes by that I don't cry about this, even though it happened 10 years ago, and I'm not ashamed of it, or I'm not, whatever it is that you're feeling about the conviction, you should also say that.
And I think another thing to mention too is that Canada is different from the United States. In the United States, it's they have interviews, sort of face-to-face interviews. But Canada is paper-based, or has documents to support the application.
Yes. Having said this, for criminality, you can be called on an interview. It's rare, but I did a lot of interviews as an officer for criminality. It will usually happen when it's a very, what we call high profile case, and it has a lot of risk, or if you have a permanent residence application and there is criminality. So, but what you're saying is true. Most of the time you will never see an officer, so it's an exercise of documents and well prepared, supported application. And that's how a firm like mine or yours can help assist clients that are serious about wanting to return to Canada or to go to Canada.
Absolutely. And so we just have a question from Angela, who asks what if a charge was laid for a minor offense but later dropped by paying the police based on the local culture and vouching of a person with status and authority, justice of the peace, who knows the offender's moral character? Can this be presented openly to IRCC?
Yes, but I didn't talk about this because it's rare, but we call that usually, so in the US, there's things like that too, not as much, but in a lot of country where the system is corrupted, there's plea bargain, right?
Mm-hmm.
People have an influential dad, so they're not going to be even brought to court. They're going to pay someone, a judge, to dismiss. So in the Immigration Act, there is, we didn't talk about it today because it's rare, but there is a part that says commission of a crime. So officers will use that if they have strong evidence that you actually commit the crime, but that you come from a country where the justice system is corrupted, and that you should still be inadmissible to Canada. Honestly speaking, it's very, very rare that an officer will use that. So most cases, if there is no conviction, and keep in mind that the officer may not have access unless it was a highly publicized case, the officer may not know all of this background information. So often, or I should say most often than not, even if these corrupted justice system were able to sweep something under the rug, it might be accepted by IRCC as you're not inadmissible to Canada because there was never any conviction.
Right.
But not always, not always. I've had cases where I would go online and check, what happened. And I'd be like, you know what? And often the person, sometimes the person will say, I've committed a crime, I just wasn't convicted of it. Then the officer, if they feel that this person is a danger to Canada and they could reoffend, then they would say, well, you're inadmissible for committing a crime. And I'm not approving any of this, right? So, like I had cases where, like there was highly publicized cases of like sexual predators and restaurants and things like that, and there was like, in countries where these can be often. Judge can be paid off, and it's like when you're looking at that as an officer and this person's going to be let into Canada, and you're like, well, there's a lot of little girls and boys in Canada,
right?
So am I willing to take a risk? So, but often they're not that publicized. But on this guy, I mean, there was just like articles and articles and articles about like how this guy is is corrupt and buying the system. You know what I mean? So,
Right.
but most often these cases, it's hard for the immigration officer to get their hands on exactly what, because they're Mr. Everybody and something went down under the curtains somewhere in a court or, somewhere. So I would say proceed with caution, but there is a risk that you could be, even though you haven't been convicted, that you're still unmissable because the officer is going to say, well, I think you committed that crime and I think you're a risk to Canadians, right?
Mm. Okay. Understand that. Just wanted to know if we have question and answers. If there any other questions?
We have both of our, if you have questions, additional
Yes.
questions, you can always email me. And you can also email Bison Immigration Consulting. Of course, if it's a long question, we will probably charge for consultation. But I think we both offer different types of services to match your budget and your level of complexity of your case, and
And
things
do you want
like
to
that.
talk about your services, just in terms of what you offer? I know you said
Already
submission
did, like,
letters.
like I'm basically, I adapt to your need and your budget usually, if it's feasible. So if you say, Annie, I just need you to do the equivalency, I got the rest, that's what we'll do for you, and we'll charge accordingly. Annie, I just want you to write the legal letter, that's what we'll do. Annie, I want you to take over my entire file, I don't want to deal with it, that's what we'll do. And of course that's going to change based on the complexity of the case, your budget, and all that. But I'm very flexible, and I try to accommodate the client's needs on what they want, what they can afford, and also with the complexity of the case. But if you come to me with a super complex case, sometimes I'll say, oof, this is not the type of case where you should just kind of be doing one part. But most times it's not, and it's like, okay, we'll just help you with this, and I think you should be, you should have a good chance at getting your approval.
And so Marcia says, so you can handle practically everything possible. And the answer is yes, and it can, absolutely.
Yes, or I'd like to think so.
RCIC.
And
Yes.
and the other thing too, like, is that when you come to me, usually the process is that we'll assess your case in a consultation.
Right.
And I will, this is my type of practice, and not everybody's like that. I tell you, I just did that to a guy last month. I said, listen, he wanted me to take, he had a lot of money, wanted me to take money. I said, I cannot take your case because I don't think this case has a chance at getting approval. I can never say legally it's 100% going to get refused, but at least for me too, I'm not going to take your money if I don't feel like I have a really good chance at getting that case approved. And even with that, and you cannot guarantee it, but you know that if I take your case, I feel pretty strongly about it. I feel like I can put forward a legal case. So that can also kind of be used for you as a gauge to know, well, I should go forward with this. Or sometimes I'll say, there's not enough passage of time. Or, because also timing in these type of application and strategic and gathering information and evidence is also something. Sometimes I'll say to someone, come back and see me in 3 years. And while you're doing that, please get this and that. But if you come in and I look at your case and I'm like, no, I think this is a good case, I can take it, then I'm very honest, very straightforward, that you have a very good chance at getting this application approved. And sometimes I'll even tell you, I'll be like, it's slow. Do you want to take the risk? Or sometimes I'll say, no, I'm not taking this application. I do not honestly feel like I have any chance of getting it approved, no matter what. Because again, like, we're not, we cannot make things disappear, right? What's there and static in your past is there. We can only address it. And if we have elements to address it legally, then that's when you have a good case. And then hopefully you'll get approved.
Right. And then I think one thing to know is many people do feel shamed or embarrassed about having had this in their past, or they have a relative or has it in their past, and sometimes that can hold them back from really moving forward with an application. So it's best to book a consultation with Annie so that you can find out what your options are, so that you don't keep on holding
And we can
yourself
even
back.
work together too, like on cases, you and I, if they feel comfortable with
Absolutely,
you. I do a lot
absolutely,
of different things, but I think you're bringing a great point. So,
yeah.
again, I've seen it all. I had grown men crying in my interview booth. I
Mhm.
do not judge. Everything is confidential.
Yeah,
So it is a safe place to get an honest opinion, because for a lot of people, like you're saying, they're just kind of holding back because they're
yeah,
ashamed, they're worried. So, and you could be kind of holding back while you have a great case that we could just put forward, and then in a few months or in a year, all this shame, all this worry, all this not being able to go to Canada is going to be gone, and you're going to be feeling so much better.
right.
Right.
And it's
So
best for you to
it's
know.
about trusting. Yeah, it's best
Right,
to know than not to know. I'm that type of person. I'd rather
definitely.
know where I
Right,
stand. And with me, I'm gonna let you know. Nope, I'm not
right,
taking this. I don't care if you want to pay me, $10,000. I'm not taking it. It's not about the money. It's about the fact that I only take cases that I feel I can really have a fairly good chance at getting an approval. And again, even with that, I can never
yeah,
guarantee it. So, because immigration is a very, how would I say, there's no crystal ball. You never know. You never
mhm,
know how it's going to go, because there's discretionary power, and these type of application, I've said it before, the discretion is huge. So you're even more at the mercy at whatever mood or values that decision maker is going to have in your case.
absolutely. So Mercy asked, can the consultation be done face to face? It's with Annie that would be a no, only because unless you're in LA, she doesn't like video call. But if you contact us, Marcia, we can make arrangements, and then we'll let you know in terms of what can be done. But if you are interested, get in contact, and then you can
Yep.
assist with
Best
moving
way,
forward.
send me or send you an
Yeah,
email. Tell us
absolutely.
what you want. Usually, the best way is to schedule a first consultation. That's where
Yes,
we kind of assess everything, and then you'll know where you stand. And
absolutely.
then after that, you can decide what you're going to do, and and that's kind of that's the route that I recommend. But again, some people come to me and they're like, Annie, I just want you to do the equivalency. No
Right,
problem. What I'll do
right.
for you. And sometimes the equivalency comes out and they're like, oh, you're not inadmissible to Canada. Thank you, Annie. And then they're
I'm
happy and
gone.
they're fine. They know they don't need to do anything, right? So you could also take it step by step as well, and hope that you have some pleasant surprise along the way and you don't really need to apply for anything.
Right. Okay, great. So Richard says, I appreciate this. I'll be working with you ASAP. So that sounds great. Richard, we look forward to hearing from you. Just have Angela typing. As I said, we please don't let what has happened kind of keep you stuck. Sometimes people call me, and they say, this has happened, and they feel very ashamed or very like afraid to move forward, almost because they don't want to hear what could be like if it's a worst case scenario. But then again, I just had somebody say this happened, something happened to them, or they did something 30 years ago, and 30 years on, they're really really afraid of moving forward. But we are moving forward, so it's a step in the right direction. So Angela says thank you, and Marcy says thank you as well.
Yeah. And I think
So
that's a very natural human reaction, right?
yes,
There's something that you did that you're not proud of. But again, again, I've seen it all. Like I have seen it all. So you're coming in a safe space. There's no judgment. Everyone makes mistake. But again, like we're saying, some people don't like that. But I will always say you're better off knowing than
right,
not knowing, especially because you're not going to get judged. And you may have a solution already that's very easy, and
right,
you don't know because you're afraid to ask.
exactly.
So and everybody's different, but that's usually by not asking you may be missing out on a potential solution for you.
Absolutely. Absolutely. So thank you so much. Annie, for
Thank you so
joining us.
much for having me.
Really
I
appreciate it.
I hope it was useful and
Really shed light.
simplified and clear, because it's such a complex, interesting but complex subject for sure.
Absolutely, absolutely. So participants, reach out to us so that you can schedule a consultation, and then we can assist you moving forward. Great. Thanks so much, everybody. Have a great night, and we will speak. Hopefully, we'll hear from some of you.
Thank you so much.
Thanks so much. Have a good night. Take care, everyone. Goodbye.
Bye.